the Venerable Chief Sanganayaka, the Vayamba Province, Reverend Darshan Sharma, ladies and gentlemen. It is a privilege to have the opportunity to address such a distinguished audience, and that too on a topic of very important and contemporary relevance to us all in Sri Lanka. Today we will discuss constitutional reform and its correlation to democratic values, which is without doubt a vital constituent in the working of any state. I would like to commence by recalling the words of Prime Minister Nehru during the Indian parliamentary debates of 1951, where he said, "A constitution must not be made a plaything of some fickle thought or some fickle fortune." These words put into context the centrality of respect that must be afforded to a constitution of a state. Aligning this with Sri Lanka, in the Sri Lankan context, would pose a thought-provoking question in light of constitutional practices, specifically within the time frame of the past 2.5 decades. All of us in this room are aware that in a short span of time, the Sri Lankan constitution has undergone changes and reversals pertaining to the alteration of the executive and parliamentary powers. And in this respect, I focus on the 17th to 21st amendments of our constitution. It can be said that there have been several considerations of political and social dimensions that have tainted the manner in which these amendments were brought about. When assessing the circumstances surrounding these amendments, it could also be seen that the powers of review of the Supreme Court have not been sufficient to prevent this occurrence. One may even say that the plethora of amendments entered into in the last 2.5 decades questions the integrity of the Constitution of Sri Lanka, as well as the sanctity that should be vested in the due respect of upholding good standards of constitutionalism. And in this context, ladies and gentlemen, it is impossible to have a discussion on constitutional reform without acknowledging the principle of constitutionalism. As we know, the concept of constitutionalism dives to the very root of the purpose behind a constitution. Within its ambit and scope lies the principles of upholding democracy, limited governance, separation of powers, transparency, and accountability, among several others. Constitutionalism can be perceived as a benchmark for good governance, the compliance of which would legitimize state governance. This also means that not every state which has a constitution is in compliance with the concept of constitutionalism. Before delving into this topic further, I would first like to touch on the responsibilities, meaning, and purpose behind the Constitution. As Thomas Jefferson once said, "In questions of power, let no more be heard of confidence in man, but bind him down for mischief by the chains of the Constitution." The Constitution of a country has been known for setting out the brickwork for the very functioning of a state. In light of that fact alone, ladies and gentlemen, it could be said that the Constitution sets out the foundation upon which a state would continue to exist and exercise its functions. A Constitution can be viewed as the intersection of the legal system, the political system, and our society. This is why a Constitution is regarded as a supreme law. It provides the framework under which all legislation, subordinate legislation, institutions and procedures operate, and also articulates the rights of the citizen, which institutions, procedures, and legislation must not infringe, and which the state must strive to ensure. D.S. Lutz, a distinguished political science professor at the University of Houston, contends that the Constitution marries power with justice, whereby it makes the operation of power procedurally predictable, upholds the rule of law, and places limits on the arbitrariness of power. It is further recognized that by providing fundamental rules about the source, transfer, accountability, and use of political power in a society, a constitution introduces a separation between the permanent, enduring institutions of the state on the one hand and the incumbent government on the other. Therefore, the constitution ensures that the government does not own the state. It simply manages the state under the authority of higher laws on behalf of us, the citizen. Now let us turn to speak on constitutional reform and constitution making, which is the epicenter of the discussion today. Almost all constitutions, and especially written constitutions, are entrenched against ordinary revision and amendment. It is this rigidity that allows constitutions to serve the purpose of enabling government by settling basic questions and removing the need to revisit questions as to basic structures. In addition, rigidity serves to limit government and ensure adherence to fundamental moral norms. Therefore, the rigidity too is reflective of the principles of constitutionalism. The mechanism of amendments is set to address both pragmatic and philosophical problems that relate to entrenchment to constitutions. The practical problems arise from inability of an entrenched constitution to respond to changing needs of society. The philosophical problems arise from the imposition of a constitution on future generations, whereby even if a constitution has a strong claim to legitimacy with respect to its framing generation, the question of legitimacy is complicated by its imposition on later generations. Amendment mechanisms of a constitution are therefore recognized broadly to serve only the following functions or reasons. That is to adjust the constitution to the environment within which the political system operates, including economic, technology, international relations, demographics, and changes in the values and the requirements, needs of the population. To correct provisions that are proved inadequate over time, and that is something which is relevant to us. Further improve constitutional rights or to strengthen democratic institutions, that is again something we need to look at. Provide for ongoing popular participation in constitution making, and in doing so, confer legitimacy on changes to the constitution as well as to the status quo. Provide a means of developing upon judicial interpretations of existing provisions of the constitution, thereby allowing for the reassertion of democratic decision making in the constitutional process. It is said that though constitutions have to be responsive to changes over time in social morals and values, they need to be protected against short-term changes or changes hastily approved without due reflection and consideration, and that is something we need to seriously consider about. This can be a construed indication of caution relating to the possible conflicts that can arise in the Constitution due to the variances and or contradictions between the pragmatic considerations of amendment making resulting from socio-political considerations versus that of constitutionalism. It is further recognized, ladies and gentlemen, that such changes may be motivated by selfish or partisan reasons. It is said that since a constitution sets the rules of a political game, those in power may be tempted to change the rules to extend or secure their tenure, marginalize the opposition or minorities, or limit civil or political rights. Such changes may weaken or even undermine democracy. Therefore, it can be said that selfish or partisan reasons are inherently detrimental to the principles of constitutionalism. Constitutionalism, in principle, makes all citizens parties to a great bargain. That is an agreement of the people or a social contract. It makes a state into a public entity, a common possession of all the citizens, and not the possession of one person, party, section of society. It is said that many historical constitutions have failed to establish a democratic constitutional order because they did not truly belong to the whole community and were not based on broad and inclusive agreements. Instead, they represented an imposition of values by one side, section or fraction of the community that wanted to exercise control over the state in order to dominate the whole. Such narrowly based or partisan constitutions, having its foundations on insufficiently widespread consensus, is said to be often perceived as illegitimate by opponents of the ruling party. They seldom outlive the particular individuals or governments that established them, and they generally fail in the task of constitutionalizing rather than personalizing power. And if one looks at our amendments 17 to 21st, we can sometimes see that occurring. Now let us look at the Sri Lankan context. The second Republican Constitution of 1978 has been subject to 21 amendments up to date in total. Starting our constitutional timeline from the Colebrook Commission reforms of 1833, which are one of the first significant constitutional reforms that established the executive and legislative councils. Further reforms in 1923, which resulted in an increase in the composition of the Legislative Council. Then the Donomo reforms of 1931, we sometimes refer to as the Donomo Constitution, which sought to transfer complete control to the Ceylonese elected representatives over their internal affairs, subject only to the reserve powers and the exercise by the governor of certain safeguarding powers. Then we have the Salisbury Constitution of 1947, which was a step forward from its predecessor, and it introduced many features such as the Westminster model of parliamentary cabinet system, the bicameral legislature, parliamentary sovereignty, judicial review of legislation, and preserving the independence of the judiciary. However, it was criticized for inadequate provisions on human rights. Sri Lanka gained its independence, as we all know, in 1948, but the country remained a dominion of the British Empire until 1972. Here ends our history of granted constitutions with the introduction of the first autochthonous Republican Constitution of 1972. Even though the 1972 Constitution stepped up in terms of provision of human rights, it also weakened concepts such as independence of judiciary and focused on strengthening parliamentary sovereignty in a manner that diminished the balance between the state organs. This once again serves as an important reminder to all of us that the nature of a constitution, being granted or autochthonous, has no bearing whatsoever on the quality or the success of a constitution. The 1972 Constitution was celebrated and accepted by the people of Sri Lanka as one which is homegrown and signified freedom and courage towards beginnings. But was this powerful mandate enough to breathe long-lasting life to the first Republican Constitution? Unfortunately, that was not the case. The way the tale of the Sri Lankan Constitution history unfolds would prove otherwise. In less than a decade, ladies and gentlemen, the first Republican Constitution was no more, and the second Republican Constitution of 1978, which is our present Constitution, came into being. As we know, the second Republican Constitution introduced an executive presidential system where the president is the head of the state and also the head of government, with a parliament from which a prime minister and a cabinet of ministers are appointed. On paper, the system imposes many checks and balances between the three organs of government, that is the executive, the legislature, and the judiciary, to create a happy balance. However, from the very inception of the presidency, and for many of the years, the reality has been where the executive president is also the head or has considerable influence over the political party that forms a majority in parliament, and the party of the prime minister and the cabinet of ministers, and that is apparent even as of to date. Consequently, the check of the parliament should have on the executive breaks down, and this is further exacerbated by the fact that appointments of members to the higher judiciary was also at the time by the president. It is in this backdrop that Parliament at the time in 2001 brought in the 17th Amendment to the Constitution, introducing many checks and balances and controls on the executive, especially in respect of appointments of high posts and senior officials. In substance, the 17th Amendment was praiseworthy, mainly due to its careful creation of the Constitutional Council, which functioned as a tool for the checks on the executive powers. The interference of the executive in making important appointments to commissions and appointments to the judiciary were curtailed. The amendment gave a wider discussion to the Constitutional Council to approve such appointments, and the executive was prevented from making appointments without the approval of the newly created Constitutional Council. But the 17th Amendment, as we all know, although being a progressive step in the direction of strengthening democratic institutions in the country and rebalancing the separation of powers, did not stand the test of time. It was as though the amendment was ahead of its time, and the state during the years of its existence was not ready to make the best use of this progressive amendment. The downfall of the 17th Amendment was caused due to the drawbacks in terms of implementation. The fault can also be directed in some sense to drafting issues that left lacunas in checks that it had intended to impose. The drafters of the amendment also did not envision that even some of the promoters of the draft may have lost interest when reticence and delay was seen in making new appointments when the first term or the first council came to an end, and also delay in the approvals for necessary funding for the operation of that council. The amendment did not have adequate provision to protect Constitutional Council from collateral attack by the executive, which provided perfect fodder for the next government whose ideology was based on a strong presidency to reverse completely this progressive amendment within a short span of 9 years. This is the 18th Amendment to the Constitution in 2010. Once again, 5 years later, upon the change of government in 2015 and the reign going back to the opposing side, the Constitutional Council is once more reinstated, this time in a better modified form, reconstituting many independent commissions, including the Elections Commission, the Public Service Commission, the Police Commission, the Bribery Commission, and several others to be manned by persons recommended by the Constitutional Council. This amendment, however, did not last even 5 years this time, and with the change of government comprising those who believed in a stronger presidency, introducing the 20th Amendment to the Constitution in 2020, and taking away the concept of the Constitutional Council, which provided a good balance between representatives of Parliament and civil society. Interestingly, ladies and gentlemen, it was the all-powerful presidency under the 20th Amendment that President Gotabaya Rajapaksa had to resign from. And one of the early catalysts for the same was, in fact, this amendment, which, if avoided, would have possibly helped the president stay in office. Interestingly, just 2 years thereafter, his successor, President Ranil Wickremesinghe, once more in the year 2022, introduced the 21st Amendment, reducing some of his powers as president and reintroducing the Constitutional Council largely in the same form as that was introduced when he was Prime Minister under the 19th Amendment. As I have now narrated, it is quite evident that even a small island, Sri Lanka, has had quite the experience with constitutional making. Even though repetitive introduction of new constitutions ceased after the second Republican Constitution, the new constitutional trend has been in the form to effect repetitive amendments and very serious amendments which have sought to define the separation of powers as well as the independence of the judiciary. Most constitutions in itself provide for its amendment. As such, the amendments mooted by successive Sri Lankan governments passed through the legal framework in place for amendment. For the want of a better word or a better phrase, Sri Lanka's constitutional history has been very colorful. However, it must be said that ultimately the constitution, the branches of government, the legal system, all have to work towards the common goal to benefit the population. This benefit can be in many forms. A developing country such as ours obviously needs to provide more resources at the disposal of its citizenry. And it needs to foster a governance system which would place the well-being of the citizenry at the helm of importance. So basic needs all would be well satisfied. In this journey, it can be objectively said that Sri Lanka has fallen short of the standards of constitutionalism that a sovereign country should strive towards, and it has not reached very far in terms of development. It is difficult to conclude that it is only the constitution which has failed. Several of the stakeholders and institutions and the overall manner in which things have been done have fallen short of upholding the ideal standard. That being said, today's discussion is limited to the Constitution, and as a brief for the meeting sets out, yes, the Constitution has not done its utmost to achieve that end, and that is what we are addressing today. At this concluding stage, I just want to leave you with this thought. One may say that the 17th, 18th, 19th, 20th, and 21st Amendments to the Constitution had the will of certain groupings of the citizenry who may have felt that that is the way it should be. Take, for example, the 18th Amendment. In and around that time, there was a consensus amongst a fair proportion of the citizenry that we need to strengthen the presidency. But as experience has shown, that system failed. That shows that even a government with a good majority may still be unable to come out with a constitution which addresses the necessary real outcomes that we all envision for this country. In this respect, we must ensure that we disassociate as much as possible constitution making being driven by political will. Pragmatically, this is easier said than done, but as our experience has shown, this is very important. And this is something we must strive for. We have many stakeholders in this room, and if we can agree to this on as a national project rather than one of a political party or government, then in that event, many of the hurdles, weaknesses, and drawbacks we previously experienced, in my view, could be overcome. Thank you very much for the patient hearing.